Hey, everybody. I think I'm live. Welcome to True Crime Wednesday, Summer Edition. Hope you guys are having a great summer. I've had a good couple weeks, and unfortunately, it's wildfire season in the high desert, and we've got some wildfires going on. So it's a little smoky here. So I'm a little raspy, but it just comes with the territory. So, hope you all are doing well. And we have a lot to talk about. There's been a lot going on in the last couple weeks. So, I'm glad you're joining me. I'm just going to let folks get joined. And I've got a couple things that I wanted to talk about um, uh, to begin with. And while we're waiting for people to join, this is nothing of earth shattering import, but I thought it was kind of amusing. So I'm going to share it with you. Let me share my screen here. Uh, so here's what we have. I don't know if I can make let me see if I can make that a little bigger. I'm going to read it to you so you get the amusement factor. But this is proof positive that DA is the DA Trina K is headed up to here with Lori Vallow. So the motion says the state of Arizona. Let me give you a little background here. Lori Vallows asked for a new trial because she was sick during one of her trials and during the Brandon Boudreaux trial. And so that is the basis of her new request for a new trial. So because of that, the prosecution said, well, then we need to see your medical records from the jail. And she threw a fit about that. So then she started yelling that the prosecution had her medical records and that was unfair and in violation of her privacy and blah blah blah. So Trina K has answered, and this motion reads: the state of Arizona, undersigned counsel, through undersigned counsel, submits for the record that the state is not in possession of any of the defendant's medical records. All information relating to the defendant's medical diagnosis comes from the defendant stating the facts on the record or from Joseph Vigil on behalf of Correctional Health Services in a filing or on the record. If the defendant objects to, so the state has been asking for the state's response to her motion for a new trial. They have been saying they wanted it sealed because it addresses some of these issues. However, it says if the defendant objects to sealing the state's response to the defendant's motion for new trial, then the court should deny the state's attempt to protect the defendant's medical history and make the state's response to defendant's motion for a new trial available to the public to view. This is as much, I am so fed up, I cannot stand one more second of it that you're ever going to get from Trina K. She's Lori's on her last nerve at this point, and although it's very professional and very terse, it's very clear that Lori has tried Miss K's patience uh, for the last time. So, yeah, the way it worked out was Lori filed a motion for a new trial, complaining that the judge made her go forward with the Brandon Boudreaux trial while she was sick. and that wasn't fair and that she's entitled to a new trial. So then the prosecution filed their response, but they asked the judge to seal it to respect her privacy because there's these medical issues in it. And then the darn Lori said, "Oh, no, no, how dare you want to seal things?" Trina K's like, "Biatch, you're the one who's made your medical records public, and now you don't want these documents sealed? Okey doke." So it's actually pretty amusing. I feel for Trina K. I really do. I think every lawyer has had a client, or in her case, an opponent who was as challenging as Lori Vallow at some point. So um, tonight, I'm just gonna continue a little bit because I do wanna give people a chance to join before I really dig into a couple of cases that I want to talk about and I want your opinion on. And since I'm asking for your opinion kind of early in the show, changing it up just a little bit, I think we'll just wait until a few more people join. In the meantime, I wanted to talk a little bit about a couple of different cases. This week, um, there was a case. Now, did I not write down where it is from? Apparently, I did not. This is a case of a newborn baby whose body was found 31 years ago, uh, on April 13th of 1994. And the cause of this infant's, this newborn's death was stab wounds. And the child had never been identified. Yes, trigger warning, folks. Um, the parents of the child had never been identified. The baby was never identified. 31 years later, they finally have used genetic genealogy and have identified the person's the parents. The biological mother's name was Cheryl Larson. Unfortunately, she died in 2018. So they're not able to question her. She was married, but when they tested her, they discovered that that the husband is not the baby's biological father. And they are still working on finding the biological father. They said at this point no charges have been filed, but the case is not closed. So we have an instance of genetic genealogy, yet again solving a long time cold case. Um, so I it's interesting, and I think we're going to see a lot more of those, but I'm not sure, that in this case, they're really going to, find justice for this baby. So, okay, let's dive into what I wanna talk about next and what I would like your opinion on. So, let me share my screen again. Oh, somebody's telling me I need the mic closer. So let me know if you're not hearing me. Um, the case I wanted to talk about, let me share my screen here, is this guy. His name is Ralph Menzies. And he was convicted in 19 well, let me back up. He is convicted of a murder that he committed in 1977. He was convicted in 1988, and sentenced to the death penalty. Now, back in Utah, before 2004, defendants were given a choice of whether they wanted to be executed by lethal injection or by firing squad. This fellow chose firing squad. Utah last used the firing squad in 2010. So, after exhausting all of his appeals, a judge signed his death warrant. But his lawyers said, hang on, not so fast. Our client is incompetent because he is suffering from dementia and he cannot understand why um, he can't understand why he would be being executed. So initially, the judge said he believed that the defendant was consistently and that the defendant consistently and rationally understood why he was facing execution. But he scheduled another hearing on the 23rd of July to review a new competency petition because his attorneys are adamant that he does not meet the criteria to be found to be competent. So, thank you, Jackie, for letting me know that you can hear me. So there's a couple of cases. The seminal case is Ford versus Wainwright from 1986. And the U.S. Supreme Court found that executing someone who was insane violates the Eighth Amendment's um, prohibition against cruel and unusual punishment. So the Supreme Court said that it was cruel and unusual punishment to execute someone who was insane. In 2007, in Panetti versus Quarterman, the court clarified that their finding wasn't tied to a specific diagnosis, but was based on the person's inability to understand the reason for the death sentence. And then finally, in 2019, in Madison versus Alabama, the court emphasized that the defense must be able to rationally understand the connection between the crime and his impending execution. So, hi, Tiff. Tiff says, hi, fam. Feels a bit like fam, doesn't it? Hi, Tiff. So, I want to know what you think. What about this guy? He committed a crime in 1977. He was convicted and sentenced to the death penalty in 1988. He had sufficient capability before 2004 to tell them that he wanted to be executed by firing squad. So at that point, he certainly was competent. But his lawyers are now saying he has dementia, and his dementia is so acute that he no longer is competent and no longer understands the reason why the death penalty is being imposed. He no longer understands the connection between the crime and the impending execution. So, curious what you all think about that. So, put your comments in, and Jen will pull them up. He has dementia. The at least one of these cases that I just talked about talks about the fact that it's not just insanity which triggers this question, but also other forms of mental disability, whether it is someone who is developmentally disabled or whether it's someone who has dementia. And there have been a lot of cases about whether someone who is intellectually disabled um, can be executed or held responsible um, for their crime. So uh, there's been a lot of questions about whether or not someone who has reduced capability, intellectual capability, even at the time of their crime, should be executed. So, um, uh, hi, Jackie. If he's truly suffering from dementia, the sentence should be commuted. Okay. Anybody else got an opinion? Leah, that's a tough one, as I've dealt with patients with dementia and my grandmother, but why did they wait 21 years after he agreed to the firing squad? And who did he kill? You know, it may be in this article. I don't remember. He was uh, he was sentenced in 1988 for kidnapping and murdering Maureen Hunsaker, a 26-year-old gas station clerk. So that is the answer to who he killed. The reason I'm sure that he wasn't executed 21 years ago is because he was um, trying to exhaust all of his appellate rights. We've seen this over and over. We've seen defendants that take decades before their death warrants are signed. I've said from the outset, I think it's very doubtful that Chad Daybell will be executed because I think that he'll die in prison before he exhausts all of his appeals. So that's the reason why. So clearly, at the time that he expressed his desire to be executed by the firing squad, he understood the connection between his crime and his possible execution. But now they're saying he just does not really understand any of it. And so his attorneys are asking for the the court to commute his death sentence um, I'm assuming, to life in prison. So, hi, PJ. He did the crime. It's funny how all of a sudden he has dementia. He needs to pay for the crime. Okay. Well, I think the law is the law, and I think that if we want to live in a society that honors law, and if we want to live in a society that honors the rule of law, then we need to carry out the rule of law when that is the judgment of the jury, the court, the people, and the people of the state. But the other question is we are a country that is governed by our constitution, and there are definitely constitutional provisions against cruel and unusual punishment, which our Supreme Court has interpreted as as executing someone who does not understand the connection between his crime and the potential execution. That person should not be executed. So it is a thorny one, and that's really why I wanted everybody to weigh in on it tonight because I thought it was an interesting discussion for us to have. Yes, exactly. That's why I don't understand why we even do the death penalty anymore. They very rarely carry it out. This is true, and it's incredibly expensive. Um, I mean, it's very expensive for the taxpayers. So I know that there are states that have removed the death penalty completely. The state of Oregon, where I am now, um, one of our prior governors, probably more than 10 years ago, issued a moratorium on executions. At that point, it was primarily because it was so difficult to get the drugs that they needed to use for executions, because the companies that manufacture them don't want their products used to kill people. And so those companies have gone out of their way to make those drugs unavailable for use in executions. A lot of states have gotten around it, like Texas, by going to compounding pharmacies that can make their own drugs out of the precursors. So they're getting around it that way. In Oregon, our last governor, Kate Brown, on her way out of office at the end of her second term, commuted all of the sentences in Oregon, everybody that was on death row, to life without parole. So my home state doesn't have anybody on death row anymore. But they still have the death penalty. So conceivably, we could have someone convicted, sentenced to the death penalty that would then be on death row, because it's not gone. Hi, Arizona. Bunk. He understood his sentence in 1988. Okay. I think that a lot of people feel this way. But I, once again, I am a person who loves and respects our Constitution. And so here's the dilemma. Our Constitution has a provision that says that that people should not, could not, cannot be subjected to cruel and unusual punishment, that the punishment has to fit the crime. Well, the punishment of death fits the crime if you've murdered someone, according to our law. And a lot of states um, have done away with the death penalty in the last few years, but there are still many states who who resurrected the death penalty in the 70s after the U.S. Supreme Court struck it down as written and required that there be a sentencing phase and that a jury make that decision and not a judge. And my home state put it on the ballot, and it was a ballot initiative. And because it was a ballot initiative, the legislature can't do away with it without going back to the voters. So that's why state of Oregon still has a death penalty law on the books, even though the Democrat governor, Kate Brown, commuted all the sentences for the people who were at that point had been sentenced to the death penalty. Um, so IDP seems to be a negotiation point. I don't know. Um, I really don't know. I think that his attorneys believe that he is not competent. I did see a question about do attorneys, yeah, don't doctors have to diagnose a person with dementia, not an attorney? Absolutely, Deborah. And the next step is that his attorneys have filed a new competency petition, and he will be reevaluated by a court appointed and sanctioned evaluator. And the evaluator will make the decision. In Idaho, um, neither side has any input on who that evaluator will be. The court picks that. So um, I see Deborah has a comment here. Sentenced when I was eight, oh, sorry. Sentenced when I was 8 years old for a crime he committed before I was born. This whole thing is wild, but I still don't know. Just let him rot, I guess. Yeah, maybe. Maybe that's maybe just leaving him in jail. Dementia is a very kind of long goodbye, but it's always terminal. It's always fatal. So I saw this comment from Deborah. Lori Vallow spent 10 months on a mental ward to determine competency. Yeah, actually, Lori was found to be incompetent and was committed to a mental hospital for restoration to be restored to competency. And that included medication and therapy and lots of talking about what everybody does in a trial and all of those things. Um, so yeah, it's a thorny question. Um, it's that area of our law that insists that we respect people's individual rights. Um, and sometimes it means that we come up with conflicting uh, decisions. You know, we come up with parts of our law that conflict with other parts. So, yes, Utah has a death penalty. And yes, the US Supreme Court has found that the death penalty is constitutional as if it is applied correctly. But on the other hand, um, our Eighth Amendment says that you cannot subject someone to cruel and unusual punishment. And our Supreme Court has interpreted that to mean that um, a person needs to be competent before they can be executed. So we'll wait to see what the Utah court does with it, but I thought it was an interesting thing for us to discuss. I have one other thing that I wanted to talk about, and that is, and I can tell you, I honestly do not understand what Corey Richens, this is once again still in Utah, uh, what Corey Richens' defense team is doing. I'm absolutely mystified. So recently, Corey Richens' defense team filed a motion to get all communication between her husband, the victim's family, and their victim advocate. Now, in just about every jurisdiction, there are victims advocates. They are employed by the district attorney's office, usually. They are here in Oregon. So, victims advocates, you saw in the Vallow trial, you saw Kay and Larry accompanied by their victim advocate to pretty much every day of trial. That person is responsible for a lot of things, responsible for explaining what is going on as the case and the investigation go on, and then responsible for making sure that the victims are supported through a trial. So in that case, you saw she had very light blonde hair, and she sat next to Kay and Larry every day of the trial, and she was there to make sure that they got in and out of the courthouse safely, and was able to take them in and out of entrances so that they weren't bothered by the press. She was able to she made sure that they were in a specific place before they testified. She made sure that the family had um, were brought lunches so that they didn't have to face going in and out of the courthouse during the luncheon break. Lots of other things. And so in Utah, there is a statute. Well, I'm going to pop that up for you, that outlines what victims advocates can do. So let me pop this up. I know it's not all that big, but I am going to read some of the important parts of it. So the statute says specifically is titled "Disclosure of Communication Given to a Victim Advocate," which is exactly what Corey Richens is trying to get. And it says a victim advocate may not disclose a confidential communication with a victim, including a confidential communication in a group therapy session, except. And then it goes on to talk about the exceptions to this rule. The criminal justice system victim advocate shall provide the confidential communication to a prosecutor who is responsible for determining whether the confidential communication is exculpatory or goes to the credibility of a witness. Okay. So if the victim advocate is given information by one of the victims that appears to be exculpatory, they have a responsibility to notify the prosecutor. The victim advocate can provide confidential communication to a parent or guardian of a victim if the victim is a minor and the parent or guardian is not the accused. Or they can provide that information to a law enforcement officer, healthcare provider, or a mental health therapist. Um, and if the prosecutor determines that the confidential communication is exculpatory or goes to the credibility of a witness, after the court notifies the victim and the defense attorney of the opportunity to be heard at an in-camera review that's in chambers, the prosecutor will present the confidential communication to the victim, defense attorney, and the court. So it says that you can't get these under with a Freedom of Information Act request for records access. And it says further, if the person is, if the victim is a minor, then they have to notify the parent or guardian whether they have disclosed the information to the prosecutor. So there's nothing in there that says that Corey Richens gets these documents. So it's a little mystifying for me to try and figure out what in the heck she's doing, because her lawyers could not have thought that at any point they would be entitled to get those records of communications between the victim's family and the victim advocate. So that one, so sorry. Um, we're still dealing with smoke and all of the things it makes happen. It's hard for me to understand why Corey Richens' family even attempted to get these, unless they are somehow alleging that somebody who's a family member has given the advocate exculpatory information. Even at that, the way that they would get that would be to go to the prosecutor and not by a subpoena. And Beth here makes a good point. The victim advocate asked for sanctions against the defense attorney. I had heard that, but I don't think the court's made a decision on that yet. So it's a little mystifying and when you hear things like that, you start to wonder about what the heck is going on with the defense team, because it doesn't seem that there's that there's any basis for them to get that information. So let's move on and continue to and talk about the continuing fallout from the Karen Read trial. Now, if you remember, there was a if you remember, there was a YouTube provider. His name is Aiden Carney. He goes by Turtle Boy, who was investigating and very invested in the Karen Reed case. Um, he's an interesting character. He's not everybody's cup of tea. He sort of leans towards the shock jock end of things, but he has been extremely diligent about digging into the Karen Reed case and digging into whether or not she's guilty and to some of the corruption in Canton and the suburban Boston area. So that case is still going on. He was charged with attempting witness intimidation for confronting some of the Alberts and McCabe's on the street. And I haven't gotten deeply into that, but those charges are still pending and his trial is coming up. But there has been other fallout that has been going on that is pretty interesting. First of all, Yuri Buchanan, he was the lieutenant who was in charge of Michael Proctor and was in on some of Proctor's text streams about Karen Reed, including, I'm writing a search warrant and looking for nudes in her phone. And Yuri Buchanan did not really they called him in lieu of calling Proctor, which was probably a smart tactical decision on the defense's part. The prosecution treated him like he was radioactive. They didn't want him on the stand at all. But they used Buchanan sort of as a surrogate for Michael Proctor because he was Proctor's immediate supervisor and Proctor was the case agent on the case. Buchanan didn't really do himself any favors on the stand in either trial, but certainly in the most recent trial, he came across as evasive and um, we still do not know what other kinds of investigations are still ongoing. The FBI is the now retired chief of police of Canton has said the FBI investigation is closed, but uh, interviews that I've seen with FBI investigators say an investigation can be closed one day and reopened the next. No investigation with the FBI is ever truly closed. So, well, now Yuri Buchanan has been rehomed to a desk job. He is no longer supervising officers, and he has been rehomed to a desk job with the Massachusetts State Police in their training and academy standards and training. So um, it appears, and who knows whether that will result in anything else, whether he's still under investigation with the MSP. Now, the other case that is really kicking up some problems is, and Buchanan was involved in that one as well, is the Brian Walsh case. And we're going to talk a little bit about that um, after we're done with Reed. So, because they really are kind of related, um, they really are kind of they're not related, but they're intertwined because all of the same players are involved in all of them. That one and Sandra Birchmore. So we'll talk a little bit more about how Buchanan is involved in that one once we finish with Karen Reed. So y'all probably remember Kelly Deaver, or Dever as she was quick to point out her name was pronounced. And she was the young rookie. She had been a Canton police officer. Sorry. She had been a Canton police officer She was a fairly young rookie at that point. On the night of John O'Keefe's death, she was just coming off shift when um, her I can't remember which one of the people that was involved in the investigation called her and asked her to stay on in overtime and come in and run the dispatch office while the officer that was on duty in dispatch went to the scene. So she came in and worked past her quitting time, worked well into the next shift, and she was running dispatch. That was also the place where all of the closed circuit cameras fed into the dispatch center, so she could see on screens what everything that was going on within the Canton Police Department. She reported to the FBI that while she was watching those cameras, Brian Higgins, who is somewhat suspicious as potentially having been responsible for John O'Keefe's death, and the Canton police chief, who were good friends, spent what she called a wildly long time in the Canton Sallyport alone with Karen Reed's car. And coincidentally, there's about 42 minutes worth of missing footage from the Canton Sallyport. So she initially told that to the FBI that she had seen them in the Sallyport. She later recanted that and reported to the FBI that she had somehow created a false memory. Now, police officers, particularly those who testify in court, their stock in trade is their credibility and their reliability on the stand. And so the very fact that she went on the stand and on the record said, I essentially lied to the FBI. I told them something that wasn't true, and it was a false memory. So she also testified she had since left Canton PD and been hired by the Boston PD and was a rookie with the Boston PD. Now Boston PD's got 3,000 officers, and the police commissioner is the guy who is in charge of all of them. He's like talking to the governor or the mayor, okay? But for some reason, he called Kelly Dever into his office and they had a one-on-one private conversation at the request of Commissioner Cox. He now denies that he had any contact with her or that he understood that she was involved somehow in the Reed case, and says the Boston PD has absolutely nothing to do with the Reed case, even though it was a Boston cop who died on another Boston cop's front yard. So Alan Jackson, Karen Reed's lead attorney, wrote a letter to the Canton or the Boston DA's office and said Officer Dever needs to be put on a Brady list. Now, what that means is that this is an officer who in the past, or a government official who in the past has given unreliable testimony. It means that defense attorneys are on notice that the Brady list exists and that these people who are on the list have at least on one occasion been dishonest with in court. And the Brady list requires that Brady requires that that the prosecution turn over anything that is exculpatory or can be used for impeachment purposes. And clearly, if you have a police officer who has admitted under oath that she lied to the FBI and that she has a problem creating false memories, that's a big red flag. So, Alan Jackson wrote a letter and said, "We need you to put Officer Dever on the Brady list." As we have heard, she's on leave from the Boston Police Department, and it's questionable whether she will be able to come back or not. If she gets put on the Brady list, it's highly unlikely. Not only will she not really be able to go back to the Boston PD, but it's very unlikely that she will ever be a police officer again. So my advice to Ms. Dever would be take a look at beauty school or learn to be a barista, because you're not going to be a cop anymore. Um, and it seems absurd to me that she threw away her career, um, for those crooked cops, for the Alberts and the McCabe's. Really? Uh, yeah. Um, so the other two cases. Oh, there's one more thing I wanted to talk about on Karen Reed. A day or so ago, it came out that a grand juror was being prosecuted for leaking confidential information out of the grand jury. And initially, all of the true crime creators out there kind of went crazy. And a lot of people were saying this is a grand juror from Karen Reed. It has to be a Karen Reed grand juror. It turned out this grand juror was attended the Karen Reed trial, and people knew her and knew she had been a grand juror, but it was not from the Karen Reed trial that she was being prosecuted. It had to do with um, a group that were giving out CDL licenses, and they were kind of fudging test scores so that people could get CDL licenses. That's commercial driver's licenses for truck drivers. So they were. It was a completely unrelated case to Karen Reed. So a lot of the creators that came out really quickly with it and right out of the chute had to come out and say, "My bad," because it did not have anything to do with Karen Reed. The other two cases that are going on in the same jurisdiction are Anna Walsh is the victim, Brian Walsh is the defendant, and Sandra Birchmore, where Matthew Farwell is the defendant. So in the Walsh case, um, Anna Walsh was, I think actually they pronounced it Anna. Anna Walsh was disappeared. She was commuting back and forth between Massachusetts and Washington, D.C. She had recently been hired for what she felt was kind of a dream job in commercial uh, real estate in Washington, D.C. However, Brian Walsh, and they had two little children, I think, may have been more, but at least two. And Brian Walsh couldn't leave the state because he was being prosecuted for selling fake Andy Warhols on eBay. So he wasn't allowed to leave the state. He was on a house arrest. So she was commuting back and forth between DC and Massachusetts. And on New Year's Day, she said she had to fly back to DC because there was a um, work emergency. Supposedly, that was his story, and she disappeared. And uh, I see a funny post. I was talking about uh, Officer Dever looking into beauty school, and Jen posted it. It reminds me of Grease. Beauty school dropout. That's one of my favorite movies. So Brian Walsh was later arrested for um, her disappearance, but her body has never been found. So one of the issues that came up was initially they asked Brian Walsh if they could see his telephone, and they wanted communications between he and Anna within a 4 or 5 day period, because that she was missing, and they were trying to determine whether or not she had willingly run away, left, whether she was being held against her will, whether they could get any idea of what her location was, whether she was thinking about hurting herself, all of those things. There was no inkling of that there had been foul play at this point. So they asked Brian Walsh if they could look at his phone communications. Well, he was a little hesitant because he had this other criminal case going on, and he had messages between he and his attorneys on the other case. So he initially said yes, and then said, "No, wait a minute, I better talk to my lawyer." So he calls his lawyer on the Andy Warhol fake case, and she then gets in touch with the district attorney, and they reach an agreement in writing through emails that says the police can look at only the communication text messages between Anna and Brian during a fixed number of days, like about 5 days. And that's all they could take. Well, then Yuri Buchanan and several other people from Massachusetts State Police are involved, and the word doesn't get passed on to them, and they pick up the phones and they do a full extraction. Well, in that full extraction, they find a lot of very incriminating Google searches. Things like how long before a body starts to smell, and how do you dismember a body, and how do a lot of really ugly Google searches. And they used those Google searches to get the warrant to search his house and his devices and the arrest warrant. And so his attorneys filed a motion to suppress and said, "Hold on, he never gave consent to search those things, and you didn't have a warrant. You only got a warrant based on the searches that you saw in a non-consensual search, because you did not have consent to go into his search history, his location data, any of those things." So, um, it has not yet been ruled on, but I think that there is a chance that all that is going to get tossed out. The judge is going to have a really hard time doing the intellectual gymnastics required to say somehow that it fits into some sort of exception, that it was inevitable discovery or exigent circumstances or some other exception to the warrant rule. I think the judge is going to have to do some real gymnastics to make that happen. So, Polio, yeah. The some of the information was on his son's iPad. The problem was, I think their iCloud accounts were all connected. So I don't think it mattered whether he did it on his son's iPad or whether he did it on his iPhone. It all was going to come to light. However, they they did not have permission to to do a full extraction on that phone. That's a problem. It's a problem because of the doctrine known as fruit of the poisonous tree. So, what that means is, if you think of it in sort of visual um, cues, if the tree is it is the illegal download of his phone, then the fruit of the poisonous tree is all the fruit that they found, all of the Google searches and location data and all of that stuff, based on that came out of the illegal search. And what the law says, and it's very long settled law, is that you cannot use what you gain from an illegal search to prosecute someone. you cannot you can't just say, "Oh, well, no harm, no foul," or whatever, and use that information. So if they use it because they knew about those searches, then they went and got a warrant. The warrant was based on those Google searches that they didn't have the authority to access. So uh, let's see. Also, can the phone scan people can't really sort stuff? Yeah, that's a big question as well. Now, what Buchanan testified to on the stand in the suppression hearing was that Cellbrite or Celebrite, however you pronounce it, is sort of an all or nothing thing. You either extract the entire phone or none. And so but then the question is, yeah, okay, but does that mean that you can look at everything that you extracted? And the answer is no. There very clearly was a written agreement between his defense attorney and the prosecutor as to the very narrow information that they could get. So the fact that then they went back and based their entire case, the arrest warrant and all of the other searches, all of the other valid search warrants on that information means it's all fruit of the poisonous tree. So I think there is at least a 50-50 chance that the judge says you can't you can't use it. And if that is the case, I think the case against Brian Walsh goes away because I don't think they have much else on Brian Walsh other than the information that was downloaded out of his phone. The Google searches, which are very incriminating, and then the location data, which showed that he was traveling around and they believe disposing of her body in pieces in dumpsters. So I think there's big liability there. And once again, that's Yuri Buchanan. So my point is that Yuri Buchanan's problems may have just begun. It may not be limited to the Karen Reed case, and it may be that he is on desk duty right now because he's the subject of a much deeper investigation. We can only hope because that police force is Massachusetts State Police is dirty and they take care of each other at the expense of pretty much anyone else. So, Beth, you're asking, did the prosecutor forget to tell the police? No, I don't believe so. But there did appear to be a miscommunication between some members of the force. That's a systemic problem. The prosecutor did tell the police, and Buchanan knew, but then he went to Washington, D.C. to start investigating on that end to see whether Anna had ever really gotten to D.C. And the police that were left, Detective Fanning, whose name you remember from Karen Reed, along with a couple of other people, went and got the phone. And either he forgot or chose not to let them know about that. About that, Michael Proctor was not. He was involved, but not necessarily involved in that piece of it, in the phone extraction. He was involved in the later executing the search warrants and finding all the evidence because there was some evidence, some tools and bloody towels, and there was some evidence in the basement. So he was responsible for collecting all that evidence, but that was after the search was already tainted by the lack of consent. So I wanted to talk a little bit about Kimberly Sullivan. This is a really weird case. But what I wanted to talk about is once again some uh, discovery issues. So, Kimberly Sullivan was the stepmother for an adult son. Now, there's some indication that he had potentially some developmental issues, but he was living with the stepmother and his father. And when his father died, he continued to live with the stepmother. And she continued to um, keep him essentially a prisoner in his room and in the house. And he went so far as to set a fire in his room in order to escape the house. Um, he he was held captive for 20 years. Yeah, he set fire to the house to escape. He weighed 68 pounds when he was found. Um, Kimberly Sullivan has not attended all of her hearings. She is out on bail and on an ankle monitor. She absolutely denies that she kept him captive or that she abused him, but I think his physical condition tells the story. And I think she's bound for the big house. But here's the interesting thing. After the son was rescued and has been being nursed back to health, um, he decided that he wanted to change his name for privacy reasons. And so he has changed his name and he does not want anyone to know his new name or where he's living. So the prosecution has asked the court for permission to withhold the victim's new name, that they would use his dead name, as people who get new names call it, and that they would not disclose it. And the defense is objecting. They want say, is it that it's a problem because the defendant they say it's a problem because they can't investigate the case if they don't know his new name. They can't get records, they can't talk to people who know him, all of those things if they don't know his new name. So I'm curious what you think. Um, the judge asked why a protective order wouldn't work um, equally. I think the bottom line is that this man does not want Kimberly Sullivan to know his new name. And then you get into the whole question of, well, but she has a right to confront her accusers and a right to confront witnesses and to cross-examine them. And if she doesn't know this person's new name, how can she do that? How can they do background checks? How can they, so there's a lot of questions that have to do with that. Um, but so here's the kind of thorny thing. If the judge issues a protective order, the protective order would say to the defense attorneys, you can have the information so you can do all your research and you can do whatever you need to do, but you can't tell your client. You cannot give your client that information. So it's kind of interesting to see what the judge is going to do. I don't believe there's been a ruling made on it yet, but we'll keep watching it. Um, while before I launch into the next thing, let me remind you, please like and subscribe. When you like, it does let people know that we're live. It does sort of push content out, and we love that. And but if you haven't subscribed, please subscribe. And as Jen was putting in the comments, YouTube has seen a lot of problem with people who have previously been subscribed suddenly being unsubscribed or their notifications being turned off. So, if you have a question, whether or not you are a subscriber, it's absolutely free. Um, but it does tell YouTube that you like this content and that you want to know when we post something. So please hit like, please subscribe. And even if you've been a longtime subscriber, please check your settings because you may have been unsubscribed unbeknownst to you. I just noticed somebody in the chat said they were late because they didn't get the notification. So do double check your settings. Um, let's talk about Donna Adelson. Wow. Um, her trial is scheduled to start on the 19th of August. And the prosecution recently, within the last month or two, gave thousands of new emails and jail calls to the defense. They were asking for extra time because they needed more time to review this new discovery. It is communication from Donna since she has been in jail. The prosecution has said that they have some concerns about the fact that non calls to Harvey that did not go through the jail recording system were made during a time when Donna's lawyers were there. And it's possible that Donna was using the telephone of one of her lawyers. Well, that's absolutely forbidden. So that's a problem. Now, they have not said that they are going to bring additional charges either against Donna or against the defense attorneys. But the judge has said that he is not going to postpone the trial. He did move it, I think, by a week to the 19th to give the prosecution a little bit more, or give the defense a little bit more time with that new discovery. So her attorneys are, one of her attorneys, Jackie Fulford, is a disgraced judge who runs her practice out of a funeral home that she owns. Um, it sort of reminded me, back in the day, I had a quilt shop and my law office was in the back of the quilt shop. It had a separate entrance and it it was really an official office, but it was in the back of a quilt shop. I think that's kind of a far cry from having your law office in the back of a funeral home, though. Yeah, that's a little creepy. But anyway, the the biggest issue, the most concerning thing has been that in those phone conversations, so when the prosecution realized, or the jail realized, that Donna was having conversations with Harvey that were not being recorded, the prosecution went out and got a warrant to tap Harvey's phone. And they have recordings that allegedly, I haven't heard the recording, so I cannot substantiate this, but according to reports, she Donna was discussing um, unaliving at least one other inmate. Now we heard Donna complaining about the fact that she had an inmate that was bullying her and extorting her um, for commissary goods, and then we find out that um, she was talking to Harvey about having an inmate unalived. She also was talking about, you'll recall that earlier there's been a lot of discussion about Rob Adelson, who is the Adelson's son. I think he's the oldest. I know Wendy's the youngest. I think Charlie's the middle and Rob's the oldest. And Rob has always had a difficult relationship with his parents and has very little contact with them. Well, Rob was interviewed by law enforcement and was deposed by law enforcement as well, or by the prosecution as well as the defense. And Rob had some uncomplimentary things to say about Donna, including that she was a person who looked after herself, that she wasn't dumb, and she was smart, and that she always looked out for herself first. And following that revelation, um, Donna was discussing with Harvey uh, having her own son, unfortunately unalived, to quote Kathy from Gossip, Rumor, and Innuendo. Um, that's pretty cold. I mean, it was bad enough unaliving her son-in-law, but her own son? Wow. She really is, as a couple of YouTube creators call her, Grandma Gotti. She's something else. So her trial is coming up. Definitely, we will be watching and commenting. We have a couple of other things that are coming up that are important to talk about. Brian Koberger is being sentenced on the 23rd of this month. And the judge has set aside 2 days for the sentencing hearing. Is it going to take that long? I don't know. I don't know because I really don't know how long some of these victim impact statements are going to take. Now, I want to remind you that in Idaho, we saw this in the Vallow case, the victims' impact statements are limited to the impact that the loss of that person has had that on their life. For example, in Lori Vallow's case, um, Tammy Daybell's sister was limited to what she could say. She couldn't say that she thought Lori was an evil person. She couldn't talk directly to Lori. She couldn't say anything directly about Lori. The only thing that she could do was to talk to the judge about um, the impact that Tammy Daybell's death had had on her personally, but she could not talk about Lori Vallow in any way. And that will be the case in the Koberger case as well. I think that is going to make a couple of the families very unhappy. I think Steve Gonsalves has been incredibly vocal and very outspoken. He is the dad who refused to go in the courtroom and refused to go in the courthouse when Brian Koberger was entering his plea. And he is the one who has been incredibly vocal about his feelings. He was very angry with the prosecution for taking the death penalty off the table and allowing Koberger to plead. So there could be some fireworks in court, and there could be some instances of the judge having to really exert some control over that proceeding. So that is also the opportunity that Brian Koberger would have to give an allocution. We heard Lori Vallow do that. We don't know whether that's something he is going to do or not. Remember that his plea agreement included that he would not appeal, that he was not eligible to appeal any of his sentence or any part of his case. So if he were to stand up and give an allocution, it wouldn't have damage on an appeal the way that the concern was that Lori's would have on her, on the outcome of her case. Lori's sentencing is also coming up, and I don't have that right on the. Oh, if you could see my office, it's a mess. I used to have a boss who said, "A clean desk is a sign of a sick mind." So my mind is quite healthy, thanks, because my desk is a mess. Um, I also loved the story that Kurt Vonnegut told about his brother. Um, Kurt Vonnegut's brother was a scientist, and one day Kurt Vonnegut walked into his brother's office, and it was a mess. There were papers piled everywhere, and there was just complete disaster. And Kurt Vonnegut said, "Oh my gosh, how do you ever find anything in here? Why don't you clean this mess up?" And his brother looked at him and said, "You think it's messy out here? You ought to see it in here." So that's what I always say. But my desk is a mess and I cannot find my list of dates. So I am not positive, but Lori's sentencing is also coming up shortly. They were waiting for a pre-sentence investigation uh, on that. So who knows whether Lori will make yet another allocution? Probably, because she definitely likes the uh, yeah, messy like my quilting studio too, Sharon. Um, she definitely likes the limelight, so I expect she probably will make some sort of statement. Here we go again. Excuse me. Don't you hate it when you get a sneeze caught sideways? Anyway, um, the last couple things I wanted to talk about Stephen Stearns and Madeline Soto. That trial is due to start jury selection is due to start on the 22nd of July, and opening statements are expected on the 25th of July. This is There are 2 cases for Stephen Stearns. Madeline Soto was the victim. She had just turned 14. If you follow, Gisela on Grizzly True Crime, she has been really involved in this case for a very long time. Yes, trigger warning. Madeline was 14. There w She was reported missing. Um, Her mother and her mother's on again, off again boyfriend reported her missing. That was Stephen Stearns. Um They reported her missing, and police talked to Stephen Stearns at different times. They asked him if they could see his phone. He willingly turned over his telephone to them because he had done not 1, but 2 factory resets on his phone and believed that they wouldn't be able to find anything on his phone. He did not understand how iCloud works, however, and the police, when they looked at his telephone, realized that there were thousands of child SA, um, CSAM materials on his phone, most of which involved Madeline Soto, since the time she was about 8 years old. So, um, like the case, the Walsh case, um, they filed a motion to suppress, saying that they had not gotten proper consent from him to search, that they had only had consent to look at Google Maps and some other things that he was trying to show them on his phone. The judge found that that was not accurate, that Stephen Stearns had repeatedly given them consent to search his phone, very likely because he thought they weren't going to find anything. Well, they did find things. So there are Stephen Stearns has 2 trials coming up. The first one, um, is the case for all of the child SA materials, the CSAM materials. Um, and it's sort of hard to understand why he is fighting this, because they really have him dead to rights, and the judge has found that all of those images are going to come in and they are horrendous. So I can't imagine that he is um, not going to be convicted. The second trial is a murder trial, for the death of Madeline Soto. So Um, one of the uh, concerns that a lot of people have, and I share with them, is the fact that this guy is um, a pedophile and that he is going to have the opportunity to view some of those images during his trial. And I think that's unfortunate. I hope that the prosecutor is going to try and limit his exposure to those images as much as possible. But that's the reality of having the right to confront witnesses and the evidence against you. So, to some extent, he is going to have exposure to those images. The judge also, um, the defense filed a motion to continue because of the news coverage. They also filed a motion not to have the trial live streamed. Both of those were denied. The judge said, nope, this trial is going forward. The last thing that he asked for were two things. He asked for no shackles and to use a regular pen. I thought the judge had a couple of interesting points to make. The deputy from a deputy from the jail came and taught, or court security came and talked to them about the devices that they use. We've talked about this before. One is a leg brace that locks uh, so that you can't bend your knee, and it makes it really impossible to run. And the other is, of course, the taser cuff that they put on. Lori Vallow had one that was a belt that went around her waist. In general, they use them, they're a cuff around their ankle. It looks like a blood pressure cuff, and that's the part of it that makes contact with the skin and can tase you if you get out of line. They made the argument, his counsel made the argument that there had been inadvertent firings of that. Now, I don't know in Florida if that's the case. When the judge was having the conversation with Lori Vallow over the stun vest, he said they're reliable and we haven't had any accidental discharges. And this judge had a different take on it and said there have been some accidental discharges, and so I'm going to order you to wear the leg brace. It's worn under the clothing, nobody can see it, and the defendant, when he sits down, there's a latch at the knee, and all you do is hit the button, and it allows it looks kind of like a knee brace that you would wear if you had knee surgery. And it's articulated and it has a latch, so you just flip the latch and it allows the knee to bend. But the minute you stand up, it latches stiff, and so you can't bend your knee, you can't run. So the judge ordered that that was what he was going to wear. The other thing that they talked about was the pens. Now, I have used and owned and gone home with many of these pens. They look like I mean, if you Google, if you Google jail pens, you can pull up a picture. But they look like the inside of a Bic pen, uh, just the cartridge, and they have the little metal ballpoint nib, and they're flexible. They're rubbery. They're uh, I mean, I've had clients sign hundreds of documents with jail pens, and walked out with one in my hand. It they use them in court and in jails all the time, because they can't the the barrel of the pen could be used as a weapon, or the the clip on the clip where pocket clip could be used, particularly if they're metal. Yeah, they sell them on Amazon. So, so they don't generally allow inmates or people in court to use anything that's hard and could be used as a weapon. I mean, you could stab somebody with a pen. It's been done before. So these pens they're flexible, the ink is in them. They're not hugely reliable, they're very inexpensive, and, they skip and, all of those things. But other the other thing that I think is that they draw attention to the person as being in custody, right? They draw attention because they're writing with this weird looking pen. So the judge, for that reason, allowed, well, thank you, Polly. Very sweet of you. We don't necessarily solicit um, uh, super chats, but we do appreciate them when you send them. So thanks so much for that. Um, so the rubber pens, they're not that great not that reliable, a little bit difficult to hold and write because they're like writing with a spaghetti noodle. Um, More like writing with a pipe cleaner. They're kind of flubsy. So, and the judge said his concern was that before the jury, it would look odd for him to be writing with an instrument that was not like everyone else's. So he ordered that Stefan Stearns can have a felt pen because they didn't want him to have a pen that had a metal tip on it. But he could use a felt pen, and that he could only use it in the courtroom, and court security would take it from him whenever he left the courtroom. So that is the last of Stefan Stearns, I think, motions before his trial starts next week. So um, a lot of you may have been watching the live stream trial of Raul Valley. He was 16 years old at the time of this incident. He was involved in a um, house party. Uh, uh, it was a whole bunch of teenagers at a house party. They were all drinking, and he was involved in a fight. Um, Someone either handed him or he pulled a knife and he stabbed the victim, Jimmy McGrath, who later passed away. His team made a self-defense argument, and the jury found him not guilty on all of the intentional murder counts, murder in the first degree, all of the intentional accounts. They deadlocked on all of the counts that included mental state of reckless. We've talked before about every statute has to have a mens rea. That's the mental state. And it has to be knowingly, intentionally, recklessly, negligently. Those are sort of the typical ones. So, murder, of course, is always an intentional act unless it is negligent homicide or reckless homicide. Um, so, all of those charges, any of the charges that had to do with him intentionally causing the death of the victim, he was found not guilty on, and the judge did what Karen Reed's case didn't do, and entered verdicts on all of the counts that the jury came to a verdict on. The judge then declared a mistrial on the parts of it that they couldn't come to agreement on, that they were hung on. And today, the prosecution announced that they are going to recharge him with the counts that the jury was hung on. But he can't be tried again for first degree murder because he was found not guilty. So they can bring the charges, but they'll all be on the lesser counts, on the lesser charges. So that was sort of interesting. And the last one I wanted to talk about is James Craig. He's the Colorado dentist who poisoned his wife's smoothie. Allegedly. He's on trial right now. This case is not being live streamed. And so a lot of folks are following it through people who are in the courtroom and are tweeting from the courtroom. Um, I know that lawyer Lee is following it really carefully and putting together a recap in the evenings from all of the various coverage from people who are in the courtroom, but it's not being live streamed. And it's got some interesting twists to it. One of the interesting twists is the prosecution. The one of their star witnesses was the office manager in James Craig's dental office because she saw him in a in an exam room where he didn't usually go, working on a computer. And a couple of days later, and he said to her, "I have a personal package coming in. When it comes in, don't open it. Just throw it on my desk." And the package came in, and somebody else in the office got it before she could tell them, "Oh, that's personal, don't open it." And they opened it and found the packing slip for cyanide, I think. Yeah. And so he claimed that he was doing some research on dental procedures that required it, but they knew that he had gotten this poison. And the office manager then Googled the symptoms because they knew that James Craig's wife had been ill and been in and out of the hospital on and off for a while. So she Googled what are the symptoms of that particular poisoning, and it was clear that James Craig's wife had all those symptoms. She then reported it. And but the interesting little twist to it is that when the defense got a hold of her to cross-examine her, they then pointed out that she had a personal relationship with James Craig. Um, she says they were friends and they had a phone number that they texted one another on, but it's unclear at this point whether it was a romantic relationship, but they had some sort of a personal relationship with one another that was above and beyond work. And the defense kind of had a heyday with that today, is my understanding. So, unfortunately, they are not going to show that. I had heard that they may show closing arguments and the verdict, but I'm not sure whether that is the case or not. So. Well, my friends, I have run through everything that I wanted to talk about, so I'm anxious to hear what you want to talk about. So we're ready to take some questions. Hi, Rachel. If somebody else already posted about this, ignore this comment. Nope, nobody has. But I wanted to say they did identify Baby Hope's bio dad. His name is Paul Shepard. He's the one who gave her the name Hope. That's right. Um, it- they identified him. He had no idea she existed. Yeah. And he it was very sad. So when he was notified, he she was an unnamed newborn, and the police who were investigating the case um named her Baby Hope. And so for 31 years she was unidentified. So she has now been identified, and her biological father has given her his last name, and he opted to have her remain Hope. So he's given her his last name, and she now has a name and an identity, and I think a headstone. So um, I think that it's a testament to law enforcement and to their tenacity, to their saying, "We're not gonna give this up until we figure it out," and, to technology, because the mother was identified um, through DNA records and through, genetic genealogy. And, so she was identified. Unfortunately, she died in 2018 or 19, and so, there aren't any real answers, to who might have been responsible for the baby's death, but, it was good that he was able to, give her an identity after all these years. So, um Anna Walsh had 3 children. Oh, thanks. Why wouldn't inevitable discovery work? Well, because inevitable discovery really means that something that you couldn't have helped but discover it. There's no way that you could have inevitably discovered those Google searches without a warrant. It's just not something that could happen. I mean, inevitable discovery, here's an example. Say police go and get a warrant because they believe that the occupants of a house are um, are selling drugs, and they go into the house and they're searching for drugs and drug paraphernalia. As they're going through the search, one of the police officers opens a drawer and there's a gun in the drawer. Well, they inevitably discovered the gun in the process of the search that they were doing that was unrelated, and when they test that gun, it turns out that it links to a murder, and it's got the bad guy's fingerprints on it. Now that's inevitable discovery, that, in the process of a search, a lawful search, something else was discovered. It is not, not inevitable discovery if you are specifically told you may look at text messages between these days and between these two phone numbers, period. And you download the entire phone and find all this other stuff on it. It would be the same if it were CSAM images or anything else. You can't use that um, for uh, to prosecute someone when you don't have a warrant. So let's see what this says. Oh, dear Jennifer Coffendoffer, Daffer. Was on a podcast today saying Koberger can make blood money from his crimes because Idaho doesn't have a son of Sam law. Well, once again, eat the food, Tina. Jennifer Coffendaffer doesn't know her butt from a hot rock and wouldn't be able to find it with a 10-hand working party. Idaho most certainly does have a son of Sam law, which we have talked about at length because we discussed whether or not Chad Daybell could make enough money to pay his attorney by selling his story. And the answer was hell no. So you all know that I do not trash talk people on the internet. You all who know me know by now, I don't badmouth other creators. I am the first one to send you to another creator's site if they have good information. Y'all know me. But Jennifer Coffendaffer is a disgrace to her professed profession as an FBI agent, as well as a disgrace to women in authority in general. So, and you are certainly more than welcome to uh, uh, screenshot this and send it to her because she's just not a nice person. She is not a good person. She does not have good intentions. She can talk all she wants about that she's there for the victims, but that's not it. Uh, that ain't it. So. Uh, She is once again incorrect. What other questions do you have? Hi, Polio. In all your research, what is with the LDS. Dentist is LDS. Is death better than divorce? Lawyer Lee is awesome on this case too. Yeah, I love Lee. I was on her show a couple of times, and I think the world of her. Um, and she has really been covering this. Girl, I do not know, but we have quite a few different cases. Um, Possibly, I mean, when you have, and I don't. I'm going to tell you that I did months and months of research on the LDS Church to write wherever you are over here, um, the book on the Vallow Daybell case. And what I'll say is that when you have those social, um, cultural constraints, because the LDS Church is as much a culture as it is a religion, and you are in a bubble where you really are only able to um, socialize with other people who are in the church. And the church believes that when you are married in the temple, you are married for time in eternity. This is different than Christian doctrine, who says, until death do us part. Um, Christian doctrine believes that when people are go to heaven, that they're a different kind of being, and that we'll all love one another as angels, as God loves us. And so that's a different idea. Um, LDS doctrine says that people are married to one another for all eternity, and that then when they die here on earth, they will go to the celestial kingdom. And if you are married in the temple, you will continue to be married in the celestial kingdom. And people have their children sealed to them, so their children are sealed into their family unit in the celestial kingdom. And they sang a hymn that was sung at Tammy Daybell's funeral about families are forever. And so they believe that that bond, that marriage in the temple, cannot be broken, and that if you are married now, you are married for eternity. That is why they are so opposed to divorce. So when you have a faith that is very opposed to divorce, I think these excesses can happen. Now, that's not to say that Mormon doctrine is telling you to kill your wife and not divorce her. That is not the case at all, and I don't want anybody to think that. But I think that when you have a faith that says you're married for time and eternity, and nothing can break that bond, and you better not divorce your wife because of that, then you have a problem, because there isn't an out. Divorce isn't an option. And Lori and Chad didn't see divorce as an option. Lori answered Melanie Gibb when Melanie Gibb said, "Why don't you just get divorced? Why doesn't Chad just get divorced?" And her answer was, because he would lose his place in heaven. So I think that is part of it, that we do see these cases. Um, James Craig, he was um, had some infidelity issues that went beyond the office manager in his office. He also was having some very serious financial problems, and so there was a lot in that case. And but I have heard that they were pretty devout LDS observant members of the church. So, what other questions have you got for me? Hello. I am not going to begin to know how to pronounce that. Arkwolok? Okay. We were talking about the first guy we were talking about, Ralph Menzies, who is on death row in Utah and is is suffering from dementia, and we talked about whether or not the death penalty should be uh, uh, implemented as it applies to him because he may not. There's still an evaluation pending. He may not understand why he would be being executed. So that's the first. So if Ralph Menzies truly has dementia, he may not have an understanding of what happens. But Stern, all for the death penalty. Yeah, the murder case for Stefan Stearns is a death penalty case in Florida. Um, it and he they are seeking the death penalty. I've had a lot of questions about why they didn't just go straight to the murder case and why they chose to bring the CSAM case first. And I think that has to do with the fact that it's an aggravating factor that plays into proving the death penalty. So convicting him of SA against this victim then is an aggravating factor in her murder. And so I think that's why. That would be my guess. I didn't do a deep dive into Florida law to double check that, but that's my guess. So, you guys got some good questions tonight. What else you got for me? Pamela Thompson, I was late, so catching up. My husband has dementia and is in the room right now. It would be like hurting a child. Yeah, I mean, I had a relative with dementia, and I agree it would be like hurting a child. Um, our legal system requires that if we are going to hold someone accountable, that they understand why that's happening. And the U.S. Supreme Court has been very clear that that the person must be able to rationally understand the connection between the crime and the impending execution. I'm reading that from a case, and that has been the U.S. Supreme Court's um, opinion that you must be able to understand the connection between the crime and the impending execution. Um, and I agree completely. I also want to say, um, Pam, eh, that is the most difficult of long goodbyes. To see someone you love fade to the point where they don't know you and they don't remember you and they don't remember the life you had together. That is a true devotion to remain devoted to someone like that and to be there for the long haul. So, anyone out there who is who is taking care of someone, please remember to take care of yourself. It's tough duty. It's hard work. Whether you are taking care of a disabled child, a parent, a spouse, um, please take care of yourself because it's tough. And that is really tough, a tough, tough job. So, what else do you have for me tonight? Well, if I don't see any other questions, last chance for questions. And if I don't see any, I will see you back here. Um, I want to remind you, and I'm just pulling up my calendar so I'll be sure that I'm giving you all the right dates. We are only meeting twice a month during the summer. I don't know about you, but I have some fun things coming up. This weekend, we are having a birthday party for my husband, and it's a big O birthday. So we're excited about that. We're having a few folks over. Some of his family's coming to visit from out of town. So we're super excited about that. My friend Jane from Boise is going to be coming to visit in a week or two, and I might even try and get up to see her in McCall to spend a little time up there. Otherwise, I'm going to be trying to float my boat as often as I can. Those of you who don't know, I loved kayak in the summer, especially up in the high lakes in here around in Central Oregon. So, looking forward to that. Um, of course, we have CrimeCon coming up the 5th, 6th, and 7th of September. So that's in Denver this year. If y'all want to join me, I will be there. And in the meantime, I'm working on a couple of new projects that I'm really excited about. And I'm hoping that in September, we'll be able to fill you in on all of that. So when those plans get a little more solidified, then I'm going to definitely clue y'all in on it. And you will definitely be part of it as we go forward. So let's talk about when we're going to do. Um, True Crime Wednesday again in August. So that is going to be August 6th and August 20th. So we'll put that in the community tab so everybody knows. But mark your calendars, and we'll be seeing you again twice in August, and then we'll be back to a regular schedule after Labor Day. So thank you for joining us. I appreciate it. I am seeing a lovely chat happening um, around being a caregiver and taking care of folks that are suffering with dementia. And I definitely appreciate all of you. It is a tall order to be called on to do that kind of work, and it really is a labor of love. So I admire and respect every one of you. Prayers for Texas, absolutely. I cannot imagine what the folks in the flooded part of Texas um, are going through, and also I think that there's some more storms and some tropical storms and some flooding expected down in the Low Country in South Carolina, Louisiana, that area. So prayers for them as well for safety. So I am going to say goodnight. Thank you so much for joining us tonight. I had a blast. I always do with you. Thank you, as always, for being the best community and the best chat ever. And I know that we're not a huge channel, but we really do have the best community. So thanks so much for that. Thank you, Jen, as always, for being the moderator with the mostest. And I will see you in a couple weeks on the 6th of August. Have a great summer. Enjoy yourself and be good to each other. Good night.